Appropriate measures at sea. Extraterritorial enforcement jurisdiction of a stateless migrant smuggling vessel. The recent migrant crisis in the Mediterranean Sea has clearly revealed the unclear legal basis for interdicting stateless migrant smuggling vessels in international waters. Despite claim to unilateral enforcement powers by some Western states, the law of the sea doesn't provide a strong jurisdictional basis for seizing such vessels outside territorial waters. Western destination states, particularly the United States or US, have responded to the legal lacuna surrounding stateless vessels by strategically waiving ambiguity through the transnational crime instrument, regulating smuggling of drugs and migrants at sea, and then claiming the ambiguity permit the exercise of coercive measures extraterritorially. The recent European Union naval operations in the Mediterranean have substantially concretized the ambiguity in the migrant smuggling protocol as permitting seizure of stateless vessels. While new maritime threats require flexible interpretation of the law of the sea, any changes to extraterritorial enforcement powers must reflect the common understanding of state. Leaving revision of the law to instrumentally ambiguous treaty, drawing and subsequent practice instead risks favoring the interests of powerful states at the expense of individual human rights and developing states. On the evening of 10 September 2013, a Frontex patrol ship sighted a large fishing boat unloading persons onto a small vessel in the international waters of the central Mediterranean Sea. The small vessel sailed on toward the Sicilian port of Syracuse and the larger fishing vessel in the direction of North Africa. The Frontex patroller trailed the small vessel overnight, monitoring its route. As conditions at sea deteriorated the following evening, the Italian Guardia di Finanza intercepted the small boat, rescuing the 199 migrants on board and leaving the vessel atrail. Meanwhile, the Frontex patroller continued to track the mothership, establishing that it didn't fly a flag and that the ship name had been erased from the hull. The patroller hailed the mothership and requested identification document from the crew. Despite receiving 15 documents in Arabic allegedly attesting that the crew were fishermen, the Guardia di Finanza boarded the mothership, detained the crew, and confiscated the vessel. Back at the port of Syracuse, the rescued migrant identified an Egyptian national, Harabi Hani, as being a migrant smuggler. He was arrested and detained before trial for facilitating illegal migration and participating in a criminal organization. Harabi Hani appealed the preliminary detention order, contending that the coercive measures used against him, detaining him in international waters and forcibly transferring him to Italy, were without basis in international law. The Italian Court of Appeal rejected Hani's application, holding that the migrant smuggling protocol gives state full enforcement powers to intercept vessels suspected of being stateless and smuggling migrants by sea. The case centered on whether the term appropriate measures in Article 8.7 of the protocol permits states to exert coercive measures over intercepted vessel beyond the board and search power contained in the United Nations Convention on the Law of the Sea or UNCLOS. The court found that the seizure of the vessel and the transfer of its crew to Italy by the Guardia di Finanza fell within the scope of the term. The case illustrates the confusion surrounding whether interdiction of vessels of uncertain nationality engaged in migrant smuggling by sea is actually permitted under international law. Since 2015, nearly 1.5 million undocumented migrants and asylum seekers have reached Europe by sea, mostly with the aid of migrant smugglers. Thousands have been rescued from small, unseaworthy vessels by humanitarian organizations, merchant or naval ships, including Frontex, Mare Nostrum, and the European Union-led mission European Union Naval Force Mediterranean, or UNEFOR-MED. Although states may intercept boats in distress in international waters, these powers do not permit general interdiction of smuggling vessels. But the lack of legal enforcement option only became apparent with the increased use of unmanned and unregistered vessels to smuggle drugs and migrants in the 1980s and 1990s. In response, Western destination states have manipulated the developing field of transnational criminal law to expand their sovereign powers beyond national borders. Stateless vessels inhabit a lacuna in international law as neither customary law nor treaty practice makes clear provision for their regulation, legality, or jurisdiction. The jurisdictional regime applicable to stateless vessels at sea is complex. In international waters, state may only exercise jurisdiction over such vessel where a jurisdictional nexus connects the intercepting state to the suspect vessel. Beyond universal jurisdiction, the basis for extension of jurisdiction extraterritorially are limited, requiring evidence that an offense was partially committed in the territory of the state or the offender possesses the nationality of residents of the intercepting state. Further states cannot easily rely on treaty-based extension of jurisdiction, as such extension technically rely on jurisdictional swaps between state parties and consequently cannot bind non-party states. In establishing jurisdiction of a stateless vessel, state effectively claim that an underlying basis exists in custom. Objection or acquiescence by the third-party state then support or rebuts the claim. Yet again, no state exists to object or acquiesce to the practice of interdicting stateless vessels. Over the last 30 years, however, treaty practice towards stateless vessels has become increasingly ambiguous. When read against the traditional principle of the law of the sea and jurisdiction in international law, the treaty provision regulating enforcement action against stateless vessels engaged in transnational crime only permits states with a jurisdictional nexus to exercise criminal jurisdiction. But Western states have repeatedly claimed the 2000 migrant smuggling protocols enables any state to seize stateless smuggling vessel and arrest vendors aboard. Tracing the transposition of the interdiction provision across the relevant instrument reveals that the ambiguity has been strategically woven through recent treaty practice. States have then relied on this ambiguity to claim enforcement action is permitted by the migrant smuggling protocol. This analysis falls within the growing body of literature emphasizing the shadow of Western hegemony falling across the transnational criminal law project. Western states increasingly rely on prohibition regime to overcome the traditional constraints on their coercive powers abroad. Wealthy developed states utilize international diplomacy, legal expertise in treaty negotiation, and subsequent practice to extraterritorialize their domestic laws and criminal justice to paradigm globally relying on custom to subsequently clarify ambiguity in the transnational crime instrument favors the sovereign interests of the dominant member of the international community, as only few states have the resources to engage in maritime interdiction outside their territorial sea as a form of subsequent practice interpreting a treaty. Thank you.